would amount to conferring excessive delegation and as such liable to be struck down. And 3, as to whether the impugn notification dated 8th of November 2016 is liable to be struck down on the ground that the decision-making process is flawed in law. In the 4th, as to whether the impugn notification dated 8th November 2016 is liable to be struck down applying the test of proportionality. And 5, as to whether the period provided for exchange of notes by the impugn notification dated 8th November 2016 can be said to be unreasonable. And the 6th one, as to whether the RBI has an independent power under subsection 2 of section 4 of the 2017 Act in isolation of provisions of section 3 and section 4(1) thereof to accept the demonetized notes beyond the period specified in notification issued under subsection 1 of section 4. Insofar as the first issue is concerned, we have considered the judgments of constitutional benches in the case of the Chief Inspector of Mines versus Lala Karamchand Thapar and Banwarilal Agrawal versus State of Bihar. And the third one, Tej Kiran Jain and others versus Sanjeeva Reddy and various other judgments of the various bench strengths, wherein word any has been interpreted. And it has been held that the word any has to be construed in context to the statutory provisions. And then the second principle which we have considered is the purposive construction. We have referred to the Constitution Bench judgments in the case of M. Petia and others. Then Chief Justice of Andhra Pradesh versus V.A. Dikshitulu and others. And Tinsukia Electric Supply Company Limited versus State of Assam, apart from the other judgments. We have held that the modern trend is of pragmatic and not pedantic interpretation. The interpretation leading to absurdity and which renders a provision to be futility has to be avoided. Any interpretation which advances the purpose and object of the legislation has to be preferred when two constructions are possible of particular provision. And applying these principles, we have held that a restrictive meaning cannot be given to word any. And insofar as issue number 2 is concerned, we again refer to the Constitution Bench judgments in Hamdard Dawakhana, Harakchand, Ratanchand Pantia, and Birla Cotton and Spinning and Weaving Mills. We have held that for finding out the policy and guidance, a resource can be added to various provisions of the Act, including the preamble, the purpose of the Act, and what is necessary is that the parent statute must consist of an essential legislative function, that is determination of legislative policy, and it is permissible in view of the multifarious activities that it is necessary for the legislature to delegate the working of details. When we have considered the status of the RBI, we have referred to the judgment of the Constitution Bench in Joseph Kurila, then the judgment authored by my learned brother Justice Ram Subramanian in Internet College. And we have specifically emphasized on the primary role of the RBI in issuance and regulations of banknotes, then its important role in monetary and economic policy of the country. Then we also considered the nature of body to whom the delegation is made. In the present case, the delegation is made to the central government, which is answerable to Parliament, and Parliaments are in fact answerable to the citizens of the country. In this respect, we have referred to the judgment of the Constitution Bench in Birla Cotton. Then in the case of Harakchand itself, when clause B of subsection 2 of section 5 was held unconstitutional, in the very same judgment, the Constitution Bench has held clause A of subsection 2 of section 5 to be constitutional on the ground that it provided that the administrator can take action after consultation with the RBI, and therefore there was self-imposed provision which required the RBI to be taken into consideration. Applying the same principle, we have held that in the present case also, the central government is required to take the action after recommendation of the central board, and therefore there is an inbuilt safeguard. And so, what the third issue is concerned, we have basically relied on the judgment in the case of Tata Cellular, wherein the scope of judicial interference in matters pertaining to is very limited. Then we have further referred to various constitutional bench judgments which are specifically dealing with interference insofar as economic policy is concerned. The judgment in Prague Ice and Oil Mills versus Union of India rendered by 7 judges. Then R.K. Garg versus Union of India. Then Sri Sitaram Sugar Company versus Union, and which has been held that there has to be a great deal of restraint insofar as interference in the matters pertaining to economic policy is concerned. The court cannot substitute its judgment for that of the legislature or the executive. It does not supplant the feel of the experts with its own views. Then we have also scrutinized the record, and after examining the record, we have found that the judicial decision-making process cannot be flawed merely because the procedure has emanated from the central government. We have construed that the term recommendation has to be construed in the context of the statutory scheme, and what is contemplated is a consultative process. And from the record, it appears that there was a consultation between the RBI and the central government over a last period of 6 months. Then, insofar as the fourth issue is concerned, we have considered the 4-pronged test held in modern dental education. One, as to whether the action was designated for a proper purpose. We find that the 3 purposes are proper purposes, and whether there was a reasonable nexus of the measure with the purpose sought to be achieved. And we have held that there was a reasonable nexus. Then, insofar as the third test with regard to alternate measures is concerned, there cannot be any alternate measures for the action which is thought to be done by demonetization. Then the fourth one is whether there was proper relation between the importance of the purpose to be achieved and the limitations on the constitutional rights, and applying all these 4 tests, we have held that the action cannot be hit by the doctrine of proportionality. Then issue number 5, with regard to reasonableness of period is concerned, we have considered that in the 1978 Act, the period provided was only 3 days, and which was extendable by a further period of 5 days. And this has been found to be a reasonable period in the case of Jayantilal Shah by the Constitutional Bench. In the present case, the period provided is 52 days, and therefore, applying the principles laid therein, it cannot be said to be an unreasonable period. Then, insofar as issue number 6 is concerned, we have held that the entire scheme of section 3 and 4 has to be considered. The powers under the provision of subsection 2 of section 4 cannot be construed in isolation, and therefore the RBI does not have an independent power. Insofar as hardship is concerned, we have referred to the judgment in the case of R.K. Garg and Sonia Bhatia, and we also considered that it is not relevant as to whether the objective achieved has objective thought has been achieved or not. So what is required is that there has to be an objective which is for the proper purposes, and there has to be a reasonable nexus with the measure and the object to be achieved. We also held that we cannot direct the central government to exercise its powers under subsection 2, and it is for the central government to exercise such a power if it finds that the exigency so arise. Accordingly, we have answered the reference as under 1. The power available to the central government under subsection 2 of section 26 of the RBI Act cannot be restricted to mean that it can be exercised only for one or some series of banknotes and not for all series of banknotes. The power can be exercised for all series of banknotes merely because on 2 earlier occasions the demonetization exercise was by plenary legislations. It cannot be held that such a power would not be available to the central government under subsection 2 of section 26 of the RBI Act. Then second, subsection 2 of section 26 of the RBI Act does not provide for excessive delegation, inasmuch as there is an inbuilt safeguard that such a power has to be exercised on the recommendation of the central board. As such, subsection 2 of section 26 of the RBI Act is not liable to be struck down on the said ground. In 3, the impugn notification dated 8th November 2016 does not suffer from any flaws in the decision-making process. 4. The impugn notification dated 8 November 2016 satisfies the test of proportionality and as such cannot be struck down on the said ground. 5. The period provided for exchange of notes while the impugn notification dated 8 November 2016 cannot be said to be unreasonable. And 6. The RBI does not possess independent power under subsection 2 of section 4 of the 2017 Act in isolation of the provisions of section 3 and 4(1) thereof to accept the demonetized notes beyond the period specified in notification issued under subsection 1, section 4 of the 2017 Act. Having answered the reference, we direct the registry to place the matter before the Honorable the Chief Justice of India for placing it before the appropriate benches. Needless to state that all other contentions are kept open to be considered by the benches before which the matter would be placed. Before parting with the judgment, we place on record our deep appreciation for the valuable assistance rendered by Sri R. Venkatramani, the learned Attorney General, Sri P. Chidambaram, Sri Sham Diwan, and Sri Jaideep Gupta, learned Senior Counsel, and all other counsels appearing for the parties.
I've had the benefit of reading the judgment proposed by His Lordship B.R. Gawai. However, I wish to differ on the reasoning and conclusions arrived at in his judgment with regard to exercise of power by the central government in subsection 2 of section 26 of the Reserve Bank of India Act 1934, hereinafter referred to as the Act for the sake of brevity, by issuance of the impugned notification dated 8 November 2016, hence my separate judgment. By way of preface, I state that the judgment proposed by His Lordship Gawai does not recognize the essential fact that the Act does not envisage initiation of demonetization of banknotes by the central government. Subsection 2 of Section 26 of the Act contemplates demonetization of banknotes at the instance of the Central Board of the Reserve Bank of India, hereinafter referred to as the Act, as the bank. Hence, if demonetization is to be initiated by the central government, such power is derived from entry 36 of list 1 of the 7th schedule to the Constitution, which speaks of currency, coinage, and legal tender foreign exchange. I've quoted the 7 issues judgments, which were, the references order dated 16th December 2016, where 9 questions were referred. His Lordship Gawai has reframed the questions referred to this Constitution bench and culled out 6 questions, which have been answered in the erudite judgment proposed by him. My views on each of such questions, as contrasted with those of His Lordship's, have been expressed in a tabular form hereunder for easy reference. It is at the head, I have put that. Then I have stated about the overview regarding the importance of the Reserve Bank of India and the Reserve Bank of India Act 1934. Then I have spoken about the history and instances of demonetization the world over, in France, in the United States of America, Britain, Congo, Ghana, Nigeria, Myanmar, Russia, Venezuela, Zimbabwe, and the history of demonetization in India in the 2 periods of 1947 and 1978. Then, while speaking about the Reserve Bank of India being the bulwark of the Indian economy, I have quoted Internet and Mobile Association of India versus RBI, wherein one of us, we, Ram Subrahmanyam J, while dealing with the regulation of cryptocurrency and virtual currency, highlighted the importance of the bank in the Indian economy. Then I've spoken about the economic and fiscal policies interference by the court and cited the judgments. What emerges from an understanding of the decisions referred to above or the subject of judicial review of economic policy may be culled out as under 1. That the court is not to sit in judgment over the merits of economic or financial policy. 2. That the scope of interference by a court is limited to instances where the impugned scheme or legislation in the economic arena has been enacted in violation of any constitutional or statutory provisions. 3. That the court may not undertake a foray into the merits, demerits, sufficiency or lack thereof, success in realizing the objectives, etc., of an economic policy, as such an analysis is the prerogative of the government in consultation with experts in the field. Being mindful of the limited scope of judicial review permissible in matters concerning economic policy decisions, I shall limit my examination of the matter to such extent as is necessary for the purpose of determining whether the process concluding in the issuance of the impugned notification was correct or as being contrary to subsection 2 of section 26 of the Act and allied aspects of the case. It may be stated at this juncture that the said aspect of the matter is not one of form, but of substance. Therefore, examining this aspect of the matter would not amount to interfering with or sitting in judgment over the merits of the policy of demonetization, and is therefore well within the limits of the Lakshman Rekha that this court has carefully drawn for itself. Then I have analyzed section 26 of the Act interpretation. There I have made again a table with a view to lend perspective to the issue with the discussion to follow. A bird's eye view of my analysis and conclusion has been expressed in a tabular form. The parameters for distinction. Then second, when the proposal for demonetization originates by way of a recommendation by the Central Board of the Bank. And the third is when the proposal for demonetization originates from the central government, as in the instant case. In that, I would say role of the central government, and the second parameter is role of the bank. The third parameter is extent of demonetization that may be proposed and carried out. Fourth, considerations for proposed measures of demonetization, illustrative. 5, process or route to be followed to carry out demonetization. And 6, applicability of subsection 2 of section 26 of the Reserve Bank of India Act. There I have stated that when the demonetization originates by way of a recommendation by the Central Board of the Bank, it is section 26(2) which applies. But when the proposal for demonetization originates from the central government, as in the instant case, it is not under section 26(2) of the Act. It is to be by way of a legislation, and if legislation is not the way in the sense there is need for secrecy, then it is ordinance. Since I have accepted the contention of the learned Attorney General appearing for Union of India in relation to the power of the central government for initiating the process of demonetization, the next question would be whether the central government can, on initiating the process of demonetization, proceed to issue a gazette notification to demonetize any or all series of any or all denomination of banknotes on the strength of subsection 2 of section 26 of the Act. Consideration of this issue would also answer the contention of learned senior counsel for the petitioners regarding subsection 2 of section 26 of the Act being unguided and arbitrary in nature and hence unconstitutional. To this end, the following aspects have to be examined. A. Whether demonetization can be initiated and carried out by the central government by issuing a notification in the Gazette of India as per subsection 2 of section 26 of the Act. B. Extent of the central government's power to carry out demonetization, that is, whether all series of all denominations may be demonetized. As held herein before, The proposal for demonetization can be followed by a legislation if the parliament is not in session, or by a plenary legislation before the parliament, and depending upon the passage of the bill as an act, carry out its proposal of demonetization. Then they have given the reasons for the same, and I have said why it should be through the legislative process. A parliament is often referred to as a nation in miniature. It is the basis for democracy. A parliament provides representation of the people of a country and makes their voices heard. Without a parliament, a democracy cannot thrive. Every democratic country needs a parliament for the smooth conduct of its governance and to give meaning to democracy in the true sense. Parliament, which is the center of our democracy, cannot be left aloof in a matter of such importance. Its views on the subject of demonetization are critical and of utmost importance. Nobody states that the impugned Gazette notification dated 8 November 2016 of the central government was published on the initiation of a proposal of demonetization by the Central Board of the Bank. Proposal for demonetization was initiated by the central government by a letter dated 7 November 2016, addressed by the Finance Secretary to the Governor of the Bank. The central government, having obtained the advice of the bank on its proposal, proceeded to issue the Gazette notification on the very next day, dated 8 November 2016. The same was followed by an ordinance, and thereafter an enactment was passed. Then in the incident case, I have said whether the central board of the bank was in a position to visualize the objectives in the incident case. Under what circumstances the central government was consulted by the central board of the bank was consulted by the central government. Then deciphering the plain meaning of subsection 2 of section 26. I said the plain meaning has to be given to this provision. Then I have said that section 3 of the act, which was also in the clause 3 of the ordinance itself, is writ with inherent contradiction, because it says notwithstanding anything contained in the Reserve Bank of India Act 1934 or any other law for the time being in force, and then says the 8th November 2016 notification issued under subsection 2 of 26. Section 26. Therefore, there is an inherent contradiction there in the provision itself. Then I have gone to the affidavits and record of the case, and the Government of India as well as the Reserve Bank of India, each of them gave 4 documents they have been looked into. And on looking into the records, I find that the use of the words or phrases such as desired by the central government had recommended the withdrawal of legal tender of existing 500 and rupees 1000 notes. Recommendation has been obtained, etc. are self-explanatory. This demonstrates that there was no independent application of mind by the bank. Neither was there any time for the bank to apply its mind in such a serious issue. This observation is being made having regard to the fact that the entire exercise of demonetization of all series of banknotes of rupees 500 and rupees 1000 was carried out in 24 hours. A situation where an independent authority such as the bank, based on its own appreciation of the economic climate of the country, recommends a measure to the central government, must be contrasted with another situation where a measure which originates from the central government is simply placed before such independent authority for seeking advice or opinion on such proposed measure. Proposal of the central government on a certain scheme having serious economic ramification has to be placed before the bank to seek its expert opinion as to its viability of such a scheme. The bank as an expert body may render advice on such a proposal, and on some occasions may even concur with the same. However, even such concurrence to a proposal originating from the central government is not akin to an original recommendation of the Central Board of the Bank within the meaning of Section 26, subsection 2 of the Act. Then I have gone through the affidavits of the Union of India and contrasted it with the affidavits of the bank. On a close reading of the notification dated 8th November 2016, in juxtaposition with the records, the following aspects emerge. One aspect of the matter which emerges with no ambiguity is that the proposal for demonetization originated from the central government by way of its letter addressed to the bank dated 7th November 2016. This aspect forms the central plank of the controversy at hand. That the recommendation did not originate from the bank under subsection 2 of section 26 of the Act, but was obtained from the bank in the form of an opinion on the proposal for demonetization submitted by the central government. Such an opinion could not be considered to be a recommendation as required by the central government in order to proceed under subsection 2 of section 26 of the Act. Even if it is assumed for the sake of argument that the said opinion was in fact a recommendation under subsection 2 of section 26 of the Act, in light of the interpretation given by me herein above to the phrase any series or any denomination, means specified series or specified denomination, the recommendation itself is void inasmuch as it pertained to demonetization of all series of banknotes of denomination values of rupees 500 and 1000. As has already been observed, the term any as appearing in subsection 2 of section 26 of the Act cannot be interpreted to mean all, as such an interpretation would vest unguided and expansive discretion with the central bank of the board, or the central board of the bank. Then legal principles applicable to the case, I have said that to do a thing a particular way or not to do at all, that is Taylor versus Taylor, Nazir Ahmed versus King Emperor, and the various cases of this court on the said principle are cited. What emerges from the above discussion is that when a statute contemplates a specific procedure to be adhered to in order to arrive at a desired end, such procedure cannot be substituted by an alternative procedure which is not contemplated under the statute. Further, if an action is to be carried out by way of issuance of a particular statutory instrument on the basis of certain requirements, such action cannot be validly carried out by issuance of an instrument when the same is not contemplated under the Act. This is particularly so when the instrument enacted stands on a different footing than the one meant to be enacted. Then I have said something about the records. Hence, in my considered view, the action of demonetization initiated by the central government by issuance of the improved notification dated 8th November 2016 was an exercise of power contrary to law and therefore unlawful. Consequently, the 2016 Ordinance and 2017 Act are also unlawful. But having regard to the fact that demonetization process was given effect to from 8th November 2016 onwards, the status quo ante cannot be restored at this point of time. What relief may be awarded in the present case? In view of the above conclusion, the question of molding the relief shall now be considered. According to the petitioners, around 86% of the volume of currency notes of the total currency in circulation in the Indian economy was demonetized. They also stated that the people of India were exposed to undue hardship owing to the lack of financial resources and had to undergo not only a severe financial crunch, but were also exposed to other socio-economic and psychological hardships. The problems associated with the measure of demonetization would make one wonder whether the central board of the bank had visualized the consequences that would follow, whether the central board of the bank had attempted to take note of the adverse effects of demonetization of such a large volume of banknotes in circulation. The objective of the central government may have been sound, just and proper, but the manner in which the said objectives were achieved and the procedure followed for the same, in my view, was not in accordance with law, having regard to the interpretation given above. It has also been brought on record that around 98% of the value of the demonetized currency have been exchanged for banknotes, which continues to be legal tender. Also, a new series of banknotes of rupees 2000 was released by the bank. This would suggest that the measure itself may not have proved to be as effective as it was hoped to be. However, this court does not base its decision on the legality of a legislation, weigh the effectiveness of such action in achieving the stated objectives. Therefore, it is clarified that any relief molded in the present case is divorce considerations of such success of the measure. Learned Attorney General, appearing on behalf of the Union of India, contended that the issues raised in these petitions have become infructuous and wholly academic, as the action of demonetization has been acted upon, and therefore the present cases are only of academic significance. It is necessary to examine the nature of relief that could be molded by the court in this matter. Thereafter, citing Bommai, Golaknath, Orissa Cement, etc., I have given my conclusions with regard to section 26(2) and the interpretation that it has to be through a legislative process. And in that summary, subpara 9, I have said the opinion of the Central Board of the Bank ought to be an independent and frank opinion after a meaningful discussion by the Central Board, which ought to be given its due weightage, having regard to the ramifications it may have on the Indian economy and the citizens of India, although it may not be binding on the central government. On receipt of a negative opinion from the Central Board of the Bank, the central government, which has initiated the demonetization process, may still intend to go ahead with the said process after weighing the pros and cons only by means of an ordinance and or parliamentary legislation, but not by issuance of the Gazette notification. In other words, the central government in such circumstances cannot resort to exercise of power under subsection 2 of section 26 of the Act by issuing a notification in the Gazette of India as if it were exercising executive powers. Even if the Central Board of the Bank concurs with the proposal of the central government, the central government would have to undertake a legislative process and not carry out the measure simply by issuing a Gazette notification. In view of the aforesaid conclusions, I am of the considered view that the impure notification dated 8th November 2016 issued under subsection 2 of section 26 of the Act is unlawful. In the circumstances, the action of demonetization of all currency notes of rupees 500 and rupees 1000 is vitiated. Further, the subsequent ordinance of 2016 and Act of 2017 incorporating the terms of the impure notification are also unlawful. However, having regard to the fact that the impure notification dated 8th November 2016 and the Act have been acted upon, the declaration of law made herein would apply prospectively and would not affect any action taken by the central government or the bank pursuant to the issuance of the notification dated 8th November 2016. This direction is being issued having regard to Article 142 of the Constitution of India. Hence, no relief is being granted to the individual matters. In view of the above conclusions, I do not think it is necessary to answer the other questions raised in the reference order. Before parting, I wish to observe that demonetization was an initiative of the central government targeted to address disparate evils plaguing the nation's economy, including practices of hoarding black money, counterfeiting, which in turn enable even greater evils, including terror funding, drug trafficking, emergence of a parallel economy, money laundering, including hawala transactions. It is beyond the pale of doubt that such a measure, which was aimed at eliminating these depraved practices, was well intentioned. The measure is reflective of concern for the economic health and security of the country and demonstrates foresight. At no point of time has any suggestion been made that the measure was motivated by anything but the best intentions and noble objects for the betterment of the nation. The measure has been regarded as unlawful only on a purely legalistic analysis of the relevant provisions of the Act and not on the objects of demonetization. In view of the answers given by me to question number 1 of the reference order, I do not deem it necessary to answer all other questions of the reference order or even the questions reframed by His Lordship B.R. Gavaije during the course of the judgment, except to the extent discussed above. In the result, the writ petitions, special leave petitions, and transfer petitions are disposed of in the aforesaid terms. All pending applications accordingly stand disposed. I would like to acknowledge and place on record my appreciation one typographical error. 1934 it has come, 1934 it was. You are given in.
Come back, don't go now.